to put together a video, kind of an intro, highlight to the HBPA, and also, something to promote all the hard work that are done day to day in every affiliate. So Dr. Daniels is coming on, we'll play that video.
Whether you're on the sport's largest stage or the smallest, we are here for you. We've always been here for you. Created for horsemen, by horsemen. Since 1940, we have helped our own through illness, hardship, emergency. The pass the hat mentality was our foundation. And now, 30,000 owners and trainers. 30 states and provinces later, we advocate and protect, standing up for all horsemen and women and the betterment of racing on all levels. Guaranteeing you are treated as partners, not bystanders. That you have a seat at the table. Every table, in every major decision impacting racing. No politics, no bureaucracy, just common sense. No other entity represents. No other entity understands. No other entity fights for you like the National HBPA.
Thank you for that. Watched it a lot too, Joe. Let me introduce somebody who needs no introduction, Dr. Doug Daniels, our National HBPA President and Chairman of the Board.
It's so nice to look out and see so many friendly faces. I've gotten to know most of you fairly well over the last few years, and I have enjoyed it very much. I'm a little tired this morning from the trip and from the reception last night. I want to thank the Arkansas HBPA for hosting our conference this year, and Good Walmsley and everybody else associated with Arkansas Horsemen. We could make this happen without you. I make this for myself now. Thank you, Luzella, for hosting our reception last night. It was really very nice and well done. The panels we have today, the panels we have at this conference, I can't find one that I look at and say, I'm not sure I can sit through them. They're going to be very, very interesting. I know we'll attend you, and I appreciate you all coming. I have two people that are taking care of me here. One from my veterinary practice, Karen Fowler, and Eddie is he's my guy. He takes care of me all day, every day. And I don't think I gave any time to sleep last night either. So, but they're working hanging there. I'm going to enjoy the panels, as I know you will. And again, thanks for coming.
Thank you, Dr. Daniels. Appreciate that. Appreciate all you do for us. So, right. Well, again, thank you to everyone for being here. Just a few housekeeping items before we get started. Again, my name is Eric Hamelback. pleasure to be the CEO of the National HBPA. This coming April, will be 11 years for me, sitting, in front of Kent Sterling, Dave Basler, Leroy Gessman, Robin Richards, Ron Moss upside down. Leroy and I were talking about that. The first meeting I had, interview was Zoom, and Ron was upside down. So it was comical to say the best, or say the least, and it was been the best situation for me. You don't have too many jobs in life unless you actually work with horses every day, and you get to, as we all say, go to work and enjoy what you do. I'm not going to say I enjoy every day for sure, because I get frustrated that people aren't listening, people don't respect this position. But I think that's what's made me pretty unique for this position. I think a lot of you know me well. I've always said Oaklawn Park is my favorite racetrack. It's the only racetrack that I have a picture of in my office. Because as a kid growing up in North Louisiana, working Louisiana Downs and then the fairgrounds, and then coming here, was always special. I lived in Dr. Cypher's clinic. Many of you from Oaklawn know Dr. Cypher's. He was the vet here for quite a while. So anyway, it's a special place for me. And again, thanks to Mr. Wayne, Lou Stella, for having us back here again. So being able to be in this position, as I said, is unique for me, kind of doing a full circle from racetrack to farm, now to industry. It gives me a good perspective. And I think that's important for anybody who's fighting for you guys on the backside, certainly fighting for trainers and owners. There needs to be an understanding of what you do. And that leads to, as I said, not all days are happy. Some of the frustration comes from people don't recognize what you do. People don't understand what it takes to get a horse from foal to race, and then just to keep them racing. So I appreciate everything that everybody in this room does, and every board member of every affiliate who isn't here, and every member of every affiliate throughout the country. Any horseman that does this for a living, we all know it's for the passion of the horse. So thank you for what you do. So I want to start just by saying again, thank you to the Arkansas HBPA for last night's reception. I think it was probably one of the best receptions we had in a while. We really enjoyed, the food was amazing. So thank you to Oaklawn staff and their chef. It was great evening. So we appreciated that. And before we get started with our first panel, what I wanted to do is just take a moment to thank all of our conference sponsors, and then also our corporate sponsors. But our conference sponsors all listed in your proceedings book, and I can't put this on without the affiliates and the sponsors who fund and help support us monetarily. Many people in this room understand how difficult it is to put on a conference and how expensive everything has become. And unlike some conferences, we're not here to make money. We just want to make sure that we break even because at the end of the day, the affiliates are the ones paying for it. So their support matters, and then obviously along with every supporter. So from the Arizona HBPA, thank you again, Lloyd, Yota, the president, and Leroy are here. Tampa Bay HBPA, Tampa Bay Downs HBPA, Mike Denny is here. Iowa HBPA president, David McShane, vice president Joe Kelly are here. Kentucky Downs, a longtime supporter of what we do and our mission, so appreciate them. The Illinois THA, yes, I said that correctly. The Illinois THA, many of you know, a lot of folks racing in Illinois, and obviously the struggles that they've gone through, but they still are supporting us because they know it means something to support horsemen and the initiatives that we drive. So HBPA, THA doesn't matter. Horseman working for Horseman matters. Naira Content Management Solutions, Jack couldn't be with us, but want to thank him for reaching out with that. Appreciate that. Alabama HBPA, Dr. David Harrington, Oregon HBPA President Ron Sutton couldn't be with us, but we have some representatives from Oregon. Obviously the Charlestown HBPA, Maria is here, and then our regional vice president, Naomi Long, is here. Louisiana HBPA, can't thank them enough, except Mike didn't bring crawfish. Must have missed that email. And then the Virginia HBPA, my man Aiden's out there somewhere, and Frank Petramalo is here as well. Also the Racetrack Television Network. Drew Schuback, who's been there for years, he and I are like many, we are retired or dismissed, gone from Athena, Magna, but Drew's done a great job of RTN spreading that, and so he's been a good friend for quite a long time. We do want to thank Elite Turf Club, and thanks to Dave Basler, who continues that support, helping facilitate their financial sponsorship. So again, the Ohio HBPA, President Joe Poole's here. Arkansas HBPA, I think we'll move on. Judge Walmsley, thank you so much. Finger Lakes, Mike, first time here to the conference, President of the Finger Lakes HBPA. Will Amwager here, appreciate that support. It's always been there for us, and really appreciate Amwager's support. Equibase, very honored to have Kyle here with us, who also will be on the panel. RGS, can't thank Racing and Gaming Services enough. My good friend and somewhat mentor, Dick Powell. Embrace the Race, who's supporting the luncheon again. Minnesota HBPA, Justin Rebeck is here, President, along with a good contingent, Julian Pablo. Indiana HBPA, Joe Davis, President, strong support, Regional Vice President. TRAO, Thoroughbred Racing Association of Oklahoma, otherwise known as the Oklahoma HBPA. Joe Offalter's drinking Coke, but he's here, happy to be here. Thanks to everybody from TRAO. Pennsylvania HBPA, Todd Mostaller, Liz Brecker's here. Kentucky HBPA, Executive Director Alex Foley being here. TOBA, Thoroughbred Owners and Breeders Association, once again, appreciate their support. And then the Iowa Thoroughbred Owners Association, Thoroughbred Owners Association through Randy is always a strong supporter of ours. So thank you to the conference sponsors. If I can ask you to give them a hand, I appreciate it. So next up, quickly, I just want to thank the corporate sponsors, and these are the sponsors that give us strong support for the Horseman's Journal in particular. The Horseman's Journal has become and was described to me by Marty Maline, a longtime executive director of Kentucky HBPA, as the Horseman's Bible. It's something each horseman can have. It's put out by our wonderful editor, Tom Law, 4 times a year, and it does have a lot of content. Quite honestly, it takes a little while to get through it all, so it's a good thing it only comes out 4 times a year. There's a lot of content in there, and we're going to try to keep that going as best we can. So thanks to our corporate sponsors. Sterling Thompson Equine, who has for years helped us with our equine liability insurance program. The Daily Racing Forum, continued supporter. SIS, Michelle Fisher, I think is on a conference call now, but great supporter of National HBPA and the Horseman's Journal. Horseman's Labor Solutions, our good friend Will Boulay, very strong supporter of what the Horsemen do, and is always there to help everyone in any sort of immigration needs. Twin Spires has come on, mainly through connections with the Claiming Crown, and I can't thank them enough for the help that they've been giving us. Cody Photography has been a great supporter. Now we obviously through the Horseman's Journal and social media use a lot of photos, and Curtis in particular has just basically opened up his his entire database and says, whatever you need, use it. So that's been a great help for us. Horsery, the AI stall monitoring camera systems, again, has been a good supporter of ours, came on last year. Good technology, hopefully can be put into use. Mike Penna and the Horse Racing Radio Network, a good friend of mine for years, always strong supporter. Crims, which you will hear from Gunner on Friday. And then last but not least, flare strips. And I say save them for last because Barkley has a table here. Stop by and talk to him. He does have some information that he's going to pass out to everyone here in a day or two. So you'll have plenty of information from him. So as we get started now with the panels that will be coming up, I want to first thank the breakfast sponsors, Virginia and Pennsylvania HBPA, for the amazing breakfast that we had here today. So appreciate that. But as maybe our panelists are getting close to coming to stage, the first panel we have here is law, litigation, and the view from the inside rail. Some of you may know where I got that phrase from, but I didn't plagiarize anything. View from the inside rail. I've got Ed Martin, Brent Malstrom, and Daniel Sir will be moderated by Pete Sakopoulos. So there's Ed. Who we missing? Brent. Brent maybe stuck on Steve Vick. We will track him down. But the panel sponsor, I'd like to thank Louisiana and Illinois HBPA for helping sponsor this panel. Let us find Brent, and then we will get started here in just a few minutes. First up, I'll introduce the moderator. Probably not unfamiliar to anyone in the room. Pete Sakopoulos has become a good friend of mine. Active owner, breeder in the state of Indiana. But for this purpose, he's got his attorney hat on, who definitely fights for every horseman, whether it's in Indiana or not. But he's been a great supporter by being speaker and moderator for us at many of our conferences. And so thank you, Pete. Appreciate all of that. So we'll turn it over to you, and we'll find Brent and get ready to start.
Can you all hear me okay? Yes, all right. Well, it's a pleasure to be with you today and to kick off your seminar here. We are going to have three distinguished speakers today to discuss the topic that Eric's just introduced, law, litigation, and view from the inside rail. We have with us today Ed Martin. Ed, for over 20 years, has been a leading figure in the regulation of horse racing in North America. He is the president and CEO of the Association of Racing Commissioners International. Last fall, the ARCI issued a report entitled 3 Years Assessing HISA. Ed will provide regulatory assessment of HISA structures, implementation, and ongoing challenges from the standpoint of state and racing authorities. Next, we will hear from Brent Malstrom. Brent owns and operates KAN Racing Stables. He is the owner that has had and continues to have concern regarding HISA. He has been involved in assisting trainers with Surfing and Jonathan Long in their challenges to HISA and to their defense of HISA and value allegations and claims. He will share firsthand insight as to why owners and trainers have pursued litigation, how HISA impacts the day-to-day participation in thoroughbred racing, and what reform horsemen believe are necessary moving forward. And finally, we will hear from Daniel Sir. Daniel is the founder of the Center for American Rights. He represents the National HBPA in its constitutional challenges to HISA. He is, in fact, our lawyer. He practices in Washington, D.C. and has spearheaded the National HBPA's constitutional challenges to HISA, and he believes, as do I, that we will prevail. Daniel will provide us with an update on the active and pending litigation in the 5th, the 6th, and the 8th circuits, and tell us where these cases stand, and we'll then discuss the constitutional questions and issues and what potential outcomes may mean for our industry. So we'll begin with Ed Martin. Ed?
There we go. Everybody hear me?
Yes.
Okay, thank you. I appreciate the opportunity to be with you all here today. The ARCI, is not pro-HISA, anti-HISA. HISA is a reality that our members in those states where HISA is in effect, is a reality, and many of my members have worked with them to try to mitigate the cost. And we'll get into some of that as this goes forward. And my intent here was to give you, kind of a big picture as to what has changed. That's why I call this the HISA difference. So what has changed? Rules of enforcement, programmatic results, cost transparency, and accountability. So let's look at what has changed. Well, for safety and medication regulation, there's one regulator, not many. There are common rules, uniform testing and enforcement, supposedly, but that's what they have the ability to do. There is increased cost. There are increased reporting and paperwork requirements on all sorts of regulated constituencies. There is limited transparency, and there is minimal regulatory agency oversight. With regard to rules and enforcement, well, the safety rules encompass many of the ARCI model rules, plus they've made some additions. The medication rules are, I'd say they're consistent with what occurred prior, but they have changed them. What has changed is a one-size-fits-all enforcement program and penalties. There is arbitration instead of adjudication. Did I get that right? There's a multi-jurisdictional enforcement entity that I found out on Monday has, for the entire country, I believe, 9 investigators. There are severe penalties for previously minor infractions. And there's a costly FTC, Federal Appeals Court process. Last summer, I'm on the racing committee of the American Horse Council, and there was a lot of talk about HISA, about the cost, a lot of private conversations, a lot of people concerned about the future of horse racing in general. They weren't saying it in public, but there were people saying in private that they fear that horse racing is dying. I don't think you can necessarily put that on any one thing, but that forced us to take a look at exactly what are the results 3 years later. What is everybody getting for what you're paying for? Well, we looked at it based on public information provided on their website by HISA and HIWU, and by public information from the state racing commissions. And here's the bottom line. The breakdown rate remains low and it's holding, although there are minor variations. Now, the breakdown rate has been heralded at one point in time, and it was a political statement. They were putting out press releases saying that, you know, that the HISA states had a 35% lower breakdown rate than the non-HISA states. And that was until like the next quarter when the HISA breakdown rate went up, and it went from a 35% decrease to a 65% increase. But the breakdown, the number of breakdowns are so small, minor variations can change the public perception dramatically. And one of the things we've suggested is that we change how we talk about breakdowns, and we talk about the ran safe rate.
I mean, they had situations, they had broad variations as to the breakdown rate of the HISA states. There were kind of, in one state it was very small, another state it was high, and then you take a state like Louisiana, which is a non-HISA state. Louisiana was better than some HISA states, and maybe not as good as other HISA states. But, you know, one or two horses can change that. HISA has made investments in artificial intelligence to include at-risk horses that they're hoping will yield future results. We couldn't address the results of those investments because it's not readily understood as to what that system is actually doing. Is it red flagging horses, or horses being scrapped based upon intelligence? And we're looking forward to learning more about them. Some of the improvements in the breakdown rate may have little to do with HISA. For instance, Arapahoe Park had no breakdowns during its last meeting. They're not a HISA track. Some non-HISA jurisdictions have lower rates than some HISA jurisdictions. The overwhelming majority of thoroughbred starters continue to run safe. In 2022, the ran safe, before HISA, ran safe rate was 99.87%. At the end of 2024, the rate was 99.9%, representing a minor 0.03% improvement. And for the first half of 2025, it slid backwards to 99.89%. Then we took a look at the anti-doping program. Well, from 2022 to the end of 2024, there was a 1.6% increase in race-related blood and urine samples tested, while the number of races increased from 26,244 in 2022 to 24,337 in 2024. There has been a significant increase in TCO2 testing. In 2024, it was about 20% of race-related HIWU testing. Only 4.1% of their adverse analytical findings were TCO2 related. There have been no new drugs or doping agents that have been called by the HIWU labs. In 2022, out of competition tests were 4.5%. After 2024, it's 7.9%. And there are out of competition tests being done in all 19 HISA regulated states. So there's been an increase in out of competition tests. HIWU controls the lab accreditations and has moved away from the RMTC lab accreditation process. We don't fully pretend to understand why, other than it obviously gives them greater control. Let's look at the costs. In 2023, the overall budget for HISA was $66,490,000. There were credits for contributions that lowered the assessments put on the industry. Those contributions came from in-kind services from state racing commissions and or certain race tracks. So the assessment on the industry in 2023 was $50,101,936. In 2024, their budget jumped to $80,956,000. And the assessments went up to, well, there was an increase in the credits, but the assessments went up to $59,846,163. In 2025, the budget jumped to $81,577,000 and change. The assessments came down a little bit to $58,783,404. In 2026, their overall budget was $78,422,000, so it came down a little bit, but the credits from states and from tracts became less. And the assessments on the industry jumped up to over 60 million. Basically, after the first 3 years, the financial impact on those who are paying, pretty much many of you in this room, is 168 million in new regulatory costs. And after 4 years, when you count into 2026, again, you know, HISA will say that these numbers are inaccurate, but these are the numbers in the budgets that were approved and the documents that are on their website. And there's some of these assessments that are in litigation. But after 4 years, that's approximately $229 million in new regulatory fees on the industry. And by the way, I don't know anybody who's not still paying your state taxes. Transparency and accountability. This is a private entity. That's different because state racing commissions were public agencies. HISA does not have public meetings. State racing commissions are required to have public meetings. There really is no real oversight by the FTC. The RCI has invited people from the FTC for us to brief them on issues with regard to racing regulation. And we've invited them to come to our conferences, and let's just say the response can be best characterized by crickets. There's no real public records access. State racing commissions have public records access. You want to find out what's going on, you can dig in, you can get anything you need to get, other than a matter that is currently under investigation. My friend Frank here is a reporter and a good digger. He's not, this stuff he's not going to be able to get. There appears to be no independent financial or programmatic audits that have been performed. State racing commissions were subject to regular financial and programmatic audit requirements, usually have to appear before an oversight committee of the state legislature and justify what they're doing and what they're asking for, and take the tough questions. And many of the tough questions would come from people who are affected by the agency, and your elected representatives will have the opportunity to basically ask the tough questions. And I've sat through many of those kind of hearings. HISA can approve its own budget and assess fees. That's not done in a public agency. Public agencies are accountable. Their legislative bodies and executive branches have to approve, and usually they assess fees. And the fees that a state racing commission might be able to assess are limited. So after 3 years, where are we? Well, I've probably been involved with racing regulation for longer than I want to admit. They're doing an incredible job. It's been bumpy. There's a greatly increased cost. The results are comparable to those previously achieved by the state racing commissions. The racing industry has lost transparency, independent financial oversight, and the checks and balances that safeguarded the public when dealing with a government agency. Now, in fairness, I will claim that they're doing greater testing than was being done at the state level. Well, that may depend on the state. My response to Mr. Moser when we had that conversation was, I can only look at whether you're detecting any new substances, There was all sorts of promises that, you know, all things that weren't being caught were going to be able to be detected. And I don't see it. It's not in any of the reports. You go down a report, they'll tell you everything that they've caught. He said, well, their testing is deeper. Well, I said, well, that may be, I don't know, maybe, you know, I understand that you're saying that, there's no way to confirm that. Maybe it is, maybe it's not, but the results, in terms of the clear rate, the number of samples you test that you don't find an adverse analytical finding that would lead to a violation, that's remained pretty much most of the samples tested. So if you had far better testing, you would think you would be having a much higher detection of your adverse analytical rate. So again, our conclusion, they're doing as good or as bad a job, depending on your point of view, than the state racing commissions were doing, but they're doing it at a far greater cost. So the ultimate questions for the industry are these. Have the results justify the increased cost? Is there a better way to achieve uniformity and comparable results at far less cost? And if so, how can that be achieved absent costly litigation and a prolonged political fight within the industry? Because it took a prolonged political fight and high-profile breakdowns in California that triggered the enactment of this statute and changed the world for everybody in this room. Only you can answer those questions. I know this organization has a counter piece of legislation. You do have another alternative on the table. Our position at the ARCI was that this statute needed technical corrections from the get-go. And I remember being on a panel with Lisa Lazarus pretty much right after she got hired. It was in Saratoga. And I called for the industry to get together, sit around the same table, talk to each other, and figure out how to fix this statute so everybody can live with it and you can get the benefits of a centralized rulemaking operation, consistent enforcement, consistent drug testing, and maybe a multi-jurisdictional investigative entity, and get everybody and hammer out a technical corrections bill that the industry could go to Congress as a non-controversial fix to make the statute work. And that would mean sitting all the entities, Jockey Club, Breeders' Cup, HBPA, THA, AAEP, whomever. But get to the same table, because I worked in Congress for 10 years of my life, and that's how he did it. When somebody slammed up a piece of legislation and most of the members didn't have an opportunity to read it because it was hidden away in a multi-thousand piece COVID relief bill, I bet you if you candidly walked up to a member of Congress and said, do you know what you just did with horse racing in this COVID bill? Having worked there for 10 years of my life, most of them would say, huh? But it was slipped in. And Congress does that. But they usually come back and do a technical correction. You never got a technical correction. And now, several years later, we have results. We have increased costs. You have alternative ideas out there. But the quickest way to fix it, unless you're going to wait for the courts, is to get everybody at the same table and come up with a consensus fix. Now, the HBPA and the USTA have a federal bill that creates an interstate compact. It's interesting, I was at a quarter horse industry in Oklahoma had a summit. And they brought people from different states. And you know what they wanted to have done? They want to create an interstate compact for quarter horse racing alone. And somebody said to me, they thanked me for not, when I was asked to speak on the matter, they thanked me for not saying, I told you so. But I did. And now we've got to figure out how to fix this. Anyway, thank you.
Thank you. And first, thank you for having me again. Last time I was able to attend in person, I was stuck. I don't remember where, but it was the world we lived in. So, thank you for having me and allowing me to share my perspective. When Eric asked me to speak and kind of give an update on, where we are with these various suits, I was happy to do so. And I just was speaking to someone right before here, and I apologize for being a few minutes late, but I was asked the question of why am I involved? Because in the two cases I'm directly involved with in the federal district court system, one is on behalf of Jonathan Long, and the other one is on behalf of Phil Serpy. First and foremost, for the record, and I want to be perfectly clear, I do not know Mr. Serpy. I have never met him. I hear very good things about him. I look forward to the day of meeting him. And yes, I am helping fund this lawsuit because I believe in the cause. I'm also funding Mr. Wong's lawsuit because I believe in his cause. And so, where we are right now, we are in the federal court system in two different districts. One's in Florida and one's in the state of Louisiana. And we're waiting for the courts to do the appropriate thing. Everything's been briefed and we're ready for, whatever's next. On the Serpy case, we're still involved with the FTC. That's been a real interesting experience where fundamentally where Mr. Serpy's case is really around the Seventh Amendment claim around is he entitled to incur the suspension and these sanctions without the right of a jury trial. And we believe that you cannot take someone's economic livelihood away from them without an appropriate opportunity to defend yourself. And in the scenario that exists today, where you go through this arbitration process, where you don't get to pick the arbitrator that's assigned, you don't get to do discovery, you don't get to do disclosures, you don't get to do depositions. It's a very difficult and challenging process. And you are literally, I like to use the analogy if you're pushing a sled uphill. But when you're talking about someone's livelihood, it matters. And I don't think that anyone should hopefully disagree with me that, if you're talking about your economic livelihood, you should have an appropriate opportunity to defend yourself. So that's what this is about. It's really fundamental fairness. It's equitable for all, and it's ensuring that there's fair play. It comes at a cost. I mean, this is not inexpensive to do. But if you don't do it, how will change occur? So I wrote an article roughly 2.5 years ago when I first, got involved in this situation around, what is happening right now. And so I look at where we started to where we are today. There have been some changes, and some of it's for the good. You're no longer going to get, your adverse analytical finding notice. You're no longer immediately suspended. Because back when this happened, and several years ago, we had 18 hours to disperse 140 voices. And that's on a 4th of July weekend. I mean, that's where we start. So there have been some progress made. Now, when you look at, what's transpired in the Wong matter, and I would preface this with, names should not matter in this conversation. What should matter is what's happened. And in this situation with this individual, there are 10 plus metformin cases that have been identified according to the HISA database. They have changed the rules, and I believe most of you are aware that they have changed the rules. They did a formal study. They changed the rules. They changed the threshold. They made changes. The thing I want to leave you with is, as a result of those changes, not one of those individuals would receive a charge letter. This would not have happened. This situation with Jonathan Wong would have never happened because the new threshold on the testing in the blood is 4.0, and Jonathan was 0.6. So we're not even close to where, we would have been in a situation. And I have a problem with that. And I have a problem with the fact that every other case that they've identified, there's not been a retraction. those names are still on the database as of this morning. And that to me is a fundamental issue, because they're still being branded and the perception is that they did something wrong. And that's not okay with me. And so, so when I think about what are we trying to do, where's this going to take us, is that I want greater accountability. I want greater financial oversight. I want conflict of interest to be disclosed, because we're dealing with that in the Serpi case, where it's come to light that the expert witness in the Serpi case was part of the consortium that recently bought the UK lab. The head of HISA's general counsel sits on the board of directors for the company that just bought the HISA lab. To us, that is a conflict of interest, and that should be disclosed, because you're talking about potentially millions of dollars potentially down the road being funneled to this new entity. And so that doesn't sit well for us. And so we have an objection to that, and we raise that objection. So we'll let the courts do what the courts do, and we will take this to wherever it takes us, because I'm trying to get equitable relief for these individuals that have had their lives completely upended. And I'm still arguing that these rules, the punishment needs to fit the crime. And so we should have an honest conversation about that. No one should, and then the other point I'd like to leave with people is that, and this is what I've said before, no one should be at risk of losing their economic livelihood by no fault of their own. And the CEO of HISA stated publicly that, I'm going to read this quote, "Our job is to serve the industry the best we can, so that we have balance, due process, and fairness to all the participants with finding the cheaters and cleaning up our sport." So we're saying that we have to balance due process. I'm not okay with that. Something should never be at the expense of due process. People are entitled to that. And just by participating in this industry, you don't give up that right. So that's what I'll leave.
Okay, amen to all of that. So I woke up this morning, and you guys are a great photographer, by the way. So I woke up this morning and I looked out on the track, and I took a video of the horses on their morning run for my nieces, because my nieces are small and horses are cool. And I noticed as I was surveying the landscape that in the center of the track, there were 3 flags. There was the US flag, and there was the Arkansas flag. And then, not what I had expected, there was an America 250 flag. Right, we are celebrating our 250th birthday as a country. And so it sort of sparked my normal nerdiness. And I actually just kind of took advantage of that moment to go back and read the Declaration of Independence, right? It's America 250, like it's time for the Declaration of Independence. And so as I was thinking about what to say to you today, again, indulge my nerdiness, let me read you a few lines from the Declaration of Independence. And remember, when Thomas Jefferson is writing these lines, they are complaints against King George. So here I'm going to quote. "He has made judges dependent on his will alone for the tenure of his offices and the amount and payment of their salaries. He has erected a multitude of new officers and sent hither swarms of officers to harass our people and eat out their substance. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws. And this jurisdiction has imposed on us taxes without our consent, has deprived us in many cases of the benefits of trial by jury, and he has refused to pass other laws unless the people relinquish the right of representation in the legislature, a right inestimable to them and formidable to tyrants only. He has taken away our charters, abolished our laws, and altered the form of our government." Does this sound like HISA to anybody? Can I get an amen? So the framers, in their genius, saw these problems in 1776, and when they wrote the Constitution in 1787, they built in protections to address the problems that they had identified. Abraham Lincoln has a wonderful line where he says, "The Constitution is the frame of silver around the apple of gold," which is the Declaration. It's actually an allusion from the book of Proverbs in the Bible, right? But the Constitution is designed to address the problems that the founders had just been living with. So the Constitution guarantees a trial by jury. Has anyone in here gotten a trial by jury from HISA? Has Phil Serby gotten a trial by jury? The Constitution says that bills for raising revenue, i.e. taxes, have to originate in the people's house. Has anyone in here gotten to vote on their HISA fees this year that are up to $229 million? And oh, by the way, that's $229 million in hard regulatory costs. That's not the soft regulatory costs of having your veterinarians constantly updating information in the system, of having your staff constantly update information in the system. That's not the soft regulatory costs of having to rebuild your racetrack to comport with the new rules, right? Like, there's a whole bunch beyond that, none of which anybody voted on. Did anybody here get to vote on the members of the HISA board that are adopting new rules? When these 9 investigators show up at your farm, have any of them shown you a badge? Or even less, a judicial warrant? Right? Like you have a Fourth Amendment right against unreasonable searches and seizures. A cop can't just take a blood sample or a urine sample without clearing it with a judge first. But that's somehow the world we live in with this stuff. And so this is why our lawsuit matters. Right? Our lawsuit is more than just about this industry. I think you guys know me well enough at this point to know I didn't come to this as a horse racing guy. I'm a constitutional lawyer, I'm a Supreme Court lawyer, and you all have just sort of adopted me kindly over the last 5 years. I came to this because it's not just about this industry. It's about our country. It's about who we are and the nature of representative government and of free people. And that is ultimately, fundamentally, why we will win. We will win because when you go in front of judges and you walk them through this, they say, well, that doesn't look right. That doesn't sound right. That's not how it's designed. That's not how the framers put the system together. Like you show them the facts, and often they're outraged because it's so different from everything they're used to. Now, obviously, that hasn't been the case in every case. There are also judges out there who are very deferential to Congress and very deferential to the industry. And so that's not the case in every case. But I think ultimately, with 9 U.S. Supreme Court justices, that will be the case. And that's why we're winning. So kind of with that as a framework, let me just turn very practically to where we are. As a lawyer, I don't make promises about how cases are going to come out, but I am happy to make predictions. So let me just sort of predict for you kind of where we are, and I think where we'll be going in the next few months to years. So as many of you know, the case that I'm privileged to represent HBPA on is in the U.S. Court of Appeals for the Fifth Circuit, right? It's the one that covers Texas and Louisiana and Mississippi. It's the one where we have won twice before on our challenge to HISA. And the primary issue before the court is the enforcement provisions right now, which, as Brent points out, are the most egregious and the ones that are most incompatible with all the principles that I just talked about 2 minutes ago. So we won there once, Congress amended the law. We won there again in 2024. The Supreme Court heard a similar case, and so sent it back to the Fifth Circuit and said, look at it in light of this new similar case. And so that is what the court is doing right now. It's looking at it in light of its similar case. I have as much confidence as I can have making a prediction and not a promise that we are going to win for a 3rd time. The frank reality is that the judge who's been with us on this has, I think it's fair to say, staked his reputation on this case. This will be one of the signature cases that Judge Duncan looks back on in his career, where he was sort of the nationally recognized leading intellectual architect in the judiciary in this area of law. And so having done this twice, he's not just gonna be like, I changed my mind, right? This is not gonna happen. I don't think that's how judges think. And so I am, again, as confident in predicting and not promising as I can, that we will win again. I think we will win again soon. Soon for a lawyer is like 30, 60, 90 days. I realize soon in the real world, that's like, man, man, killing it. It's like, I used to work in business, what are you talking about? But I think 30, 60, 90 days, we'll get another ruling from the circuit. It will reiterate what he has held previously, and it will be a win for us, which is great. Which is great. It's what we need right now. After that win comes out, the question you're all going to ask me is, what's next, right? Like, what do we do now? And do we actually win? I think some states, some of Ed's members, maybe some states, will take that win as an opportunity to do what they want to do otherwise, and give it, I won't say as an excuse, but as a reason to do what they want to do otherwise, right? Some of you have asked me in the past, like, should we keep paying our fees? Or should we start simulcasting? Or should we start simulcasting abroad, but not even domestically, right? I realize that many of you want to adjust your business models based on the legal developments. And so for those of you who are anxious for a reason to do what you want to do, my hope is that winning in the Fifth Circuit in the next few months will give you, your members, your lawyers, potentially your state regulators, the confidence that you need to go forward with doing what you want to do. I think ultimately, we're going to be back where we were before we got sidetracked, which is at the US Supreme Court. Anytime that an act of Congress gets struck down, that's like a really big deal, right? As it says, like these are laws that are at least theoretically adopted thoughtfully. And so the courts recognize their obligation really to Congress to take it seriously when a court strikes down an act of Congress. And so the Supreme Court virtually always takes those cases. In this particular instance, we have on top of that the fact that the Sixth Circuit has ruled already upholding HISA the second time around. You can read the opinion for yourselves. I know there are a few lawyers in the room who probably have read the opinion for themselves. I find it very intellectually unsatisfying. I think, frankly, even Judge Sutton, who wrote it, finds it intellectually unsatisfying. There's a couple of sections at the end where he's just desperately trying to justify the decision. And so he said, one of the complaints you hear is that HISA picks and chooses who it prosecutes. And so we could always just have the FTC pass a rule saying prosecute person X if HISA refuses to prosecute because they're playing favorites. And this was just like a really funny moment to me, because one of the other things that the founders were dealing with was that King George used to say, I don't like him, prosecute person X. And so we actually have in the Constitution a clause called the Bill of Attainder Clause. Now you guys are really indulgent in reading this, so thank you. Right? The Bill of Attainder Clause, which says Congress cannot pass a law saying put person X in jail. That's unconstitutional. And now we're basically having a judge rationalize HISA by saying, well, the FTC could always pass a rule of attainder saying put person X in jail. I don't think you can HISA jail. I don't think you can do that, right? I think the opinion is totally intellectually unsatisfying. And I think that other judges will see that and recognize that. And ultimately, I think the US Supreme Court will see that and recognize that. So my goal has always been to sort of force what Ed is hoping for, which is to make Congress go back in and open this up again, right? So it's just, I'll put it this way. I have two teenage boys, so you will appreciate rules without an enforcement mechanism are not rules, right? The way we as lawyers would say it is that if a provision is not severable, if you can't cut it out of the law, then the whole law falls. We can't have rules provisions and not have enforcement provisions. So if the court agrees with us just on the enforcement part and strikes that down, the whole bill fails. And if the whole bill fails, then Congress has to go back and fix the problem. And so at that point, we will essentially force Congress's hand. What that fix looks like is not up to me, right? That is for Ed, that is for Eric, that is for all of you to figure out. And it could look like a lot of different things. It could look like RGSA, it could look like something else. But the goal is whether just with the Fifth Circuit or ultimately with the US Supreme Court to force Congress to go back and start from scratch. Wipe the slate clean and start from scratch. It won't be totally wiping the slate clean. There's going to be some potential accountability for what has happened in the last 5 years. There have been several hundred millions of dollars that potentially have been taken in violation of people's constitutional rights or spent on activities that violate people's constitutional rights. So we're going to have some legal accountability for those decisions potentially. But ultimately, on a go-forward basis, it's really going to be on you guys of the industry to figure out, okay, after we wipe the slate clean, what's next? So that is my hope, that is my goal, that is my prediction that, you know, we'll win at the Fifth Circuit in the next couple of months. It'll go to the US Supreme Court. I continue to feel confident that we will win there. It may be that winning at the Fifth Circuit is enough to get Congress to act on its own. It's not like we can all look to Congress as a model of legislative efficiency any more than we can look to the courts as a model of judicial efficiency. So I don't think it will be just winning at the Fifth. It'll probably be winning at the Supreme Court. But I think that's kind of where we're headed. So let me close one by saying thank you. As always, we're privileged for my law firm to represent you. Many of you are generous in supporting us philanthropically, which also is very much something I'm grateful for. But let me close with this. I made this comment last time when I was chatting with Jeanette and some of the friends from our host stay here, that every time I have a case, I actually have the privilege of having two clients. One client is the person I represent. And in that case, as was mentioned earlier, that's you guys, right? Like my client is the HBPA. But my other client in all of my cases is the Constitution, right? And that's not true for most lawyers. Most lawyers, most of the time, they have a client who pays their bills. And the client comes to them with a legal problem. I'm this really unique lawyer who goes out and has to go find clients to go, like, let me represent you for free so that we can go save the country. And I believe genuinely that is what we're doing. That when you look back to those principles, when you see that American 250 flag, and you remember who we are as a country and how we got here, it was based on certain fundamental truths about what it means to be a free people, secure in our rights and liberties. And when those rights and liberties get violated, it is, I think, really our obligations as citizens to do something about it. But that takes courage, right? It is not easy to stand up to your regulator, right? It's maybe easier for me, I'm a lawyer. You guys are the ones who have to deal with these people every day on the backside of the track, right? You guys are the ones who have to deal with these people every day when they show up at your times. It's not easy to have courage in the face of the bully. But that's what we teach our teenagers at home, that sometimes you gotta stand up to the bully. That's what we're doing right now, and it's a privilege to do it with you. Thanks for having me.
Okay. I think what we've heard from all three of our speakers in various aspects is a need for reform. One, if I can just indulge me for a moment, one of the reforms I felt to be very important as one that represents for a long time licensees and here in the last 3 years covered persons is what alternatives do you have to litigate? Because many in this industry simply cannot afford to go through the administrative gauntlet and then try to look at judicial review. It's simply too expensive. I made that argument to state regulators. I made the argument both HISA and the highway. What you've done is you've placed a price tag on due process that is too expensive for the average person to purchase. In other words, you're leaving these people who are participating in your industry the inability to purchase the ticket to get into the due process room. One of the reforms I felt be important is the need to have mediation introduced into the system of adjudication. And that both is needed at the state level and with HISA and highway. I think that there has been progress made. Initially, when I represented people both before state regulators and before HISA and highway, the answer was just plain no. And why was the answer no? Because you're dealing with unequal power. One side has all of the cards and the other side really has very few. So if you think about this, and if we were on the other side and we were able to bring the charge and we were able to prosecute the claim and we were able to select the judge and hire the judge and pay the judge, why in the world would we want somebody that's neutral? But the fact is, if what you're tasked with is fairly and uniformly enforcing rules, then you would want an independent to assist in trying to resolve this in an economic way for the person who's been charged with an alleged violation. So after 3 years, we now have a proposed rule for mediation. It's not perfect, but it's certainly a step forward. Whether that proposed rule will get through with HISA and highway, I don't know. But I think it's a step forward, and I believe it to be one that will need to be reformed itself. We still have the current rule, will allow, proposed rule, will allow them to select the mediator, and it will be selecting from somebody on their side of the fence. Typically, in a
You're
case.
saying in HISA, they make the judges dependent on their will alone for their tenure in office and their salary?
And so, but in a state court matter or in a federal court matter, or wherever it might be, the general method to go about selecting a mediator or neutral to try to help get your case settled is both sides offer up somebody they think would be a good person to try to get it resolved. There's give and take, both sides have input as to who this neutral person is going to be. Under the current proposed rule, that's not the case. Now that's important because in HISA, remember, and in highway, you don't have a right like you do in a state court proceeding. You don't have a right to change the judge, which you would have automatically in most state court proceedings. You don't have an automatic right to mediation. You don't have that. And under the current proposed rule, if one side decides mediation is not what they want, well, then they don't have to do it. Of course, we know where that's going to lead, is that one side wants mediation, the other side says, I don't think it's going to be fruitful because our case is really strong. I've always been one as a litigator and one representing enforcement to tell the regulators, whether it's one of Ed's people or whether it's a highway or HISA lawyer, if you have the witnesses that are going to provide this damning testimony, and you have the evidence, you have these documents, then bring it forward and we'll deal with it. But to simply step back and say we won't try or we won't agree to that to me is not a fair approach, and nor is it consistent with fairly and uniformly enforcing these rules. So I mentioned that by way of an example for the need to reform, one that's dear and dear to me, because I think that mediation is a very good process and it resolves a lot of matters, and it provides an opportunity for those in our industry to get a matter resolved in an efficient and an economical way without going through months of trying to deal with arbitration and then appeal. And remember, now that we're under HISA and highway, that appeal is not to the state court down the street. The appeal is to U.S. appellate court. And the cost of that is often into the tens of thousands of dollars, again, something that just prices the average person in the industry out of the game, meaning out of the due process room. So with the theme being that of reform, I would ask the speakers, what do you think would be 2 or 3 major areas of reform that we need going forward with regard to our topic here of HISA law litigation and the view from the inside record? Ed, you want to start?
So if I had a wand and I could wave it, I'll go back to a conversation I had when I first met Charlie Shearer, who's the chairman of the HISA board, shortly after he got appointed. I said, you've got a tremendous opportunity to deal with those issues of lack of uniformity and so forth. The best advice I can give you is don't rebuild things that are not broken and already paid for, because it'll be the cost. If you do that, that will ultimately kill you. And 3 years later, everybody who has to pay that cost or gets caught up in this adjudication. So I would go back to that. Somebody, and I won't mention who, asked me that they heard that they could do HISA for 40% less than what they're doing now. They asked me what I thought about it. I said, my opinion is they can do it for less. Whether it's 40%, 30%, I don't know, because I can't look under the hood and see how the money's being spent. I do know for a fact, there have been situations where a state on the East Coast got a tip from a different investigator that they wanted to toss somebody's Chevron. And this particular state said, well, we'll do it for you. He said, no, we don't want you to do it. And then I put 3 people on a plane from the West Coast to fly in and toss this stall. It could have been tossed by one investigator working for the state commission. When you can set your own budget and you can, set your own taxes, then, and I'm not. So I would go back and say that there needs to be a very serious discussion as to how to fix this, or we just wait for the court decision. But this industry, in some parts of this country, is flatlining and it's in trouble. And I don't know how long we've got to wait. You've got states that are, where the racetracks are questioning whether they're gonna simulcast or not simulcast, run as many races as they used to run. It's going great in Kentucky. But there is a world beyond Kentucky. And, I hear it from my members are worried about their local tracks. It's not that it's a tough job regulating this industry. But to fix it, you've got to handle each case individually. You can't have one size fits all. You cannot assume people are guilty first and make them prove their innocence. I mean, when I first saw that, I said, this is America, isn't it? But, given how I don't want to get into politics, but, there is a growing movement that's very different. I think it can be fixed. I was asked, can it be fixed, or does it need to be wholesale replaced? Well, I think the board is not really accountable. They designed it to have a majority of people who didn't have any background in horse racing. And then they considered if you were a member of the state racing commission or RCI, you were part of the industry and therefore compromised and not independent. And I'm like scratching my head like, wait a minute. These racing commissions are independent regulatory commissions created by statute and overseen and publicly accountable. So number one, I would make HISA subjected to the Federal Advisory Committee Act, which requires open meetings, checks and balances, financial accountability, public records access. That's number one. But I do think the structure of the board should be revisited because, and I'm not a lawyer, I've been practicing law for, 40 years without a license.
My favorite kind of those.
Was a hearing officer in New York and had a decision upheld by the Second Circuit Court of Appeals, which is pretty good for a non-lawyer. I believe there were 2 Supreme Court cases that turned, one involved the Secretary of the HHS and an independent organization, and I don't, forgive me for not remembering the specifics, and those are involving, I think, the FCC. But the organization, these were found unconstitutional because the entity that was doing whatever it is we were supposed to be doing was not accountable to the secretary or the elected officials or the president or whatever. Well, with all due respect to the HISA board, and I know some of them and I like them, I just think this is structured wrong and could have been corrected in a technical correction though, but we never would have met you if they had done it. The adjudication system was paid for, is still paid for at the state level. You didn't need to totally replicate that. You didn't need to replicate private attorneys coming in to prosecute cases. You had prosecutors at these state racing commissions who frankly had never in their experience lost a drug case. Most of them. Occasionally you get caught up in a chain of custody matter, but that was rare. And you dealt with situations where you gave people the ability to present information where you would mitigate a penalty. And in a case like you were just mentioning, where they've changed their threshold, if I had a pending case, I would dismiss that case, even though it was brought under the old rule, or I'd say time served, you can come back in and do it, because we got it wrong.
We did request that. And we were told no. Yeah, I mean, when they revised, when they changed the rule for the Wong situation, when they changed the rules, we went to them and said, hey, why don't you stay a suspension until you make your determination? And then if you keep the course, then you suspend it again. But if you change, then you should be allowed, the favorability and the equitable relief of your change. They changed the rules. He is the only one that they have prosecuted. He is the only one that served 2-year suspension, $25,000 fine, because a direct quote, I won't name who named it, but we have all the audio tapes, we have the emails. We're looking forward to discovery, by the way, and positions that I'll just leave it with. We're coming. At the end of the day, they went on the record and said he's a bad guy. So the prosecution was driven by the motive of a bias of he's a bad guy. It doesn't matter, because the quote was, well, he may not have done this, but he's done these other things. Well, that's an issue, because you're being prosecuted for what you supposedly have done, not the perception of who you are or what you may have done in the past. And that's an issue. And so, and I interrupted, I apologize, but, furthering this on the accountability front, the absurdity of some of these rules, and I've highlighted a couple of them. Rule 31.1, proof of violations, presumes lab methods and standards are correct. They picked 6 labs. 4 of the 6 have lost their accreditation. One of them is a direct result of our case, because we highlighted the inefficiencies and the lab defects. While we're still adjudicating this, the FTC ruled that while the lab failures are in place, they acknowledge there is no chain of custody, by the way. They can't account for the blood or the urine or weeks upon, but the assumption is what was there, but they can't account for it. So you have no chain of custody. We were denied DNA testing on multiple occasions. So this individual lost his economic livelihood because he's a bad guy. That's the reason he was prosecuted. And, and I'm speaking frankly and plainly because, we're 2+ years into this. I'm several millions of dollars into this from a litigation perspective. And we still have the same issues. They aren't fixed. So the point is, unless they get fixed, we're going to continue to have this problem. And I think some great points have been raised. You know, I was asked this question earlier, and so I would ask everybody in this room, because all of you have a vested interest in this industry. I'm a participant. I'm an owner. I've only been in the industry since 2012. I did not grow up in it. I love it. I'm passionate about it. But what I'd ask this room is that if you think back from whatever point in time, 2012, 10 years ago, do you think we're better off today than we were? And then let me plant this other seed. How is this industry going to look in 10 more years when it's highly likely and probable California and Florida may not be in existence from a racing perspective? So then it's what's next. So this is the time to correct the regulatory side as well as the broader economic model, which is a whole different discussion, but the time is now. If we wait, it's going to be too late. And so the answer to this question and the solve for this isn't in the courts. It's to sit down at the table and have a conversation and resolve what the issues are. That's how we will get this fixed. We can do the court route. I mean, hell, we're this far into it. We'll take it to wherever it takes us. But that's not an effective, efficient way to run an industry.
You know, the quickest way you get everybody to sit at the table, because this industry has not been able to sit at the table to sort this out, would be if somebody with political influence in Congress would flip something into a must-pass piece of legislation that provided a sunset, and then boy, oh boy, wouldn't you see everybody come to the table and have a real discussion? And there's people who have that kind of influence.
Yeah. I mean, this industry is, had very prominent folks in it, and so it's kind of perplexing sometimes for me of why we're having what some candidates and very remedial conversations, and so this issue with this regulatory body, the first thing that has to change is this them versus us attitude. I mean, that has to change. Everyone at the table, in this room, wherever you are, online, has a vested interest. We all want to see this succeed. So if we go with the basic premise that we all want to see it succeed, well, then let's have a healthy conversation and debate how you get there. You have to start somewhere.
I had a bunch of, when I was the executive director in New York, I had a bunch of investigators, and I just remember, even if you thought somebody was stone cold guilty, you need to treat them with respect. You're innocent until proven guilty. And, the one thing at the end of the day, and I remember saying this at an organization of racing investigators conference a couple of years ago, is, this is about consent of the government, okay? And you get the consent, even if people disagree with you, they hate you, they appeal what you're doing and so forth. You have to have the respect. You have to have the respect that at least you're trying to do the right thing and you're listening to what they have to say. But, you have the evidence. You got the evidence and there you go. But it's how you deal with people. There's a lot of good people in this industry just trying to get by, trying to do their jobs, trying to keep their horses healthy. It doesn't mean they're all cheating. And you got to respect it. Especially if you have absolutely no experience prior to taking the position you have in providing equine care. And, I had the staff and investigatory team for the New York, now the New York Gaming Commission, but it's New York Racing Wager Board. And I took people, half my investigative force were people who had experience in the industry working with horses, and the other half were former law enforcement. Because I figured the horse folks would learn from the law enforcement and the law enforcement people. And I tell you, I had the law enforcement investigators never wanted to dive into a manure pile to chase a syringe, but the racetrackers would. Anyway.
Let's move everybody a hand. Sorry about that. What a great panel. Very happy we've got some time for questions. So I got your thoughts. I'll come to Dave as I'm coming to Dave. I will ask the first question to the two attorneys. Because this is a real world experience very recently, but it goes to the point of how their regulations were written. So the question is, and I really enjoy asking attorneys yes and no questions because they can't answer them with a yes or no. Recently, we had an incident where a racetrack employee for a trainer who is not covered, right? So he does never registered with HISA, but on the backside, and his car was searched by HIWU investigators. So it's an uncovered person. While being on a covered facility, their vehicle was searched. So the question is, in your opinion, the way HIWU and HISA regulations are written, does that search occur legally?
No.
All right, there's one.
Think about it very practically. If the standard is, we as an organization have jurisdiction over everybody on the racetrack, by virtue of their presence on the property, that means that every fan, every person working in the restaurant, every person taking tickets, right? At that point, your jurisdiction is geography based rather than license based. And like, that's fine. You could have written the law that way, right? We have other laws that way. If you went to Hot Springs National Park down the road, your jurisdiction is going to switch from the City of Hot Springs Police Department to the National Park Service Rangers because of where your geography is. So like, you can write laws that way. They did not write these laws this way, right? It's tied to license. And frankly, part of the important reason it's tied to license in their incorrect conception of the world is because licensees consent, right? Their whole idea is, well, you waived your constitutional rights when you consented to sign up and get a license. Now, I don't think that's how waiver of constitutional rights works, but that's their theory of the case. That guy never consented, right? So, no.
I agree with my lawyer.
My question's for Ed, and I think it goes to both Brent and Ed's points regarding lack of transparency and lack of uniformity with HISA. Ed, do you know if your member commissions receive from HISA notifications of positives that subsequently get tossed out for a split sample?
So this gets very interesting. I don't know. The state agencies that are working with HISA on the enforcement side have to sign NDAs. And the use of that information is kept very close. So I cannot answer that question at all. I can ask, but chances are they're not allowed to tell me.
So I ask it for a reason. In the 16 years prior to HISA that I was the executive director in Ohio, Ohio's rule was that you could not get a split sample until after you had a hearing. It had been publicly disclosed, you appealed it, then you got a split sample. Whether that's right or wrong, I don't know, but that's how it worked in Ohio. In those 16 years, there were 2 positives that were slightly over the limit for controlled therapy medications. I advised, I was a lawyer as an HBPA representative, them to go ahead and take the split sample. On the split, they came back slightly under the limits, so they were tossed out. Perfectly logical, makes sense. 2 and 16 years. Since HISA's come along, less than 3 years, I'm aware of 3 cases in Ohio where split samples have been tossed out. None of them have been publicly disclosed. The only reason that I'm aware of them is because the trainers came to me prior to and subsequently said, just got dismissed. One of them was a regiment case that hits straight on Jonathan Ball's case. It tested positive just prior to HISA submitting to the FTC a rule change proposal to change regimen from a banned substance to a controlled therapeutic medication. What do I do? I said, well, you've got the option to do a split sample. It's going to be $2,000. Called me back 2 weeks later. He says, they called me back and said they lost the split sample. I don't have to do anything. It's done. 2 weeks prior to that, young female trainer in Maryland went through the hearing process with the FTC, 2 years, $25,000 fine for Regimate and gelding. They had 2 pending Regimates and geldings that they suddenly decided time served. This was back when if you had a prohibited substance, you were out. You didn't get a grace period. The principle. We won the grace period, so it's good, but that was before that. One was 45 days, I believe, somewhere in that range. One was 90 some days. So we've got 2 years, 25,000, 45 days, 90 days, and my guy in Ohio got 0. Without an explanation, without a public disclosure. I know 3 of them in 3 years, and I don't know how many trainers haven't called me and told me about it. I'm confident there are more. It's not transparent. It's not uniform. I don't know how it's being done or who it's being done for, but I can promise you it's not uniform, it's not transparent, and Ed indicates some of his racing commissions may know, but even if they do know, they couldn't say because they have to sign a non-disclosure.
Yeah, I don't know, does the title have an agreement with them?
They do not.
Yeah, so they wouldn't be told anyway.
They're not told it.
You're not gonna get the answers to any of this stuff. Because the entities that would have the ability to basically do a programmatic, in-depth, deep dive, frankly, are the FTC and an oversight subcommittee of Congress. And that would be about it. Now, you're gonna tell Congress, which is fighting about all sorts of other stuff, that they should spend a whole lot of time digging into horse racing. Good luck with that one. But the job really does belong with the FTC. And under the prior president, you had an FTC chairman get in front of a congressional committee and said he didn't know anything about horse racing. And I think there's one person on staff who's an attorney. Well, I'm not sure what she knows about horse racing, but she's invited to come to our meeting and start the alarm, but I'm Bill Walmsley from Arkansas, and I have a request that you'll address a question I haven't heard this morning. I am fearful of how many racetracks in this country are going to be able to survive just the amount of dues that they're required to pay. I think we've got a lot of tracks in this country that the amount of their dues is the equivalent of the profit that the owner would otherwise make. And I'm wondering how long those people will continue trying to run a racetrack if they're not making any money because they're paying out $1 million, $1.5 million, or $2 million in HISA dues. Can y'all give me an idea of what, if HISA remains in effect, what racing is going to look like 10 years down the road? How many of the tracks that are there now may be gone? Can you give me some thoughts on that?
So don't call me a conspiracy theorist, but there are those of you, I'm sure, in the room who say this was the point. That's how I see nodding heads. This is how they designed it, right? So one of the things that's been interesting to me in watching this fight unfold is how many political folks have gotten involved because it's a jobs issue in their state, right? When I talk to state attorneys general and try to convince them to file in our cases, with some of them, they're nerds like me and they love the constitutional issues. But for a lot of them, you know, they're former district attorneys who've now been elected to attorney general. That's not what moves them. What moves them is this is a jobs issue. And the reason it's a jobs issue is because if we continue down the current track, there will be fewer rate cuts. And the irony to me in this has always been that NTRA, which is supposed to be looking out for its members, i.e. the racetracks, is, you know, not only pushing this, but it's like renting them free office space, right? And this is what Brent's things. Like the organization, it's like this double problem. On the one hand, how do you have as your landlord the people you're supposed to be regulating? Like that makes no sense in any rational conflict of interest world. But separately, if you're the landlord, why are you renting to people who are trying to drive half of your members out of business? This makes no sense.
Judge, I think, I have no hard numbers, but anecdotally, I hear this from a number of different states. And that's why the cost issue has got to be addressed, even if this were to survive, they've got to make some major changes to lower that cost. And I'm not sure, given how they're structured and built so far, that that's even possible. The other issue is not just the racetracks and the venues themselves. It's also the breeding industry. And I remember having this conversation several years ago, that if horse racing starts to diminish because of the cost of all this, then there'll be a trickle up effect that will affect places like Kentucky. Because if you don't need as many horses, because you don't have the horse racing, what's that going to do to the value of maybe not the upper echelon, but all the other breeds? You know, this is a very complicated industry, and so I fear for that as much, and that's a constituency I don't think has been adequately engaged in this, other than initially to help get the bill through. But again, that was the upper echelon. There's a lot of people who are not buying and selling horses at that level, that, you know, have, you know, businesses that depend on this, and it's going to affect a lot of people.
Let me ask Daniel and Brent one other thing. Eric asked a question about the fellow that was not a covered person going on to the parking lot of the training facility and having his vehicle searched, and the issue of the waiver. I think, Brent, you can speak to that about the fact that that was raised in a certain case and it's been briefed pretty thoroughly, that was not a voluntary waiver of your constitutional rights, because everyone had to sign up for HISA and become a covered person if they wanted to keep going with their career in horse racing. So I know the court in the Southern District of Florida is going to be addressing that shortly, but I thought the briefs were excellent in that regard, to show that that was not a voluntary waiver and should not be effective for anybody. You don't give up your constitutional rights that easy.
Well, it's you have to register or you can't play. So you have no option. And quite frankly, they're by checking a box on a website that offers no other disclosures about what it is that you're doing is fundamentally not correct. And at no point should you be, no one should ever be in a situation where by participating in a sport, you're foregoing your rights.
So it's a great question, Peter. So, and it's one I think judges understand, because judges do this every day. Right? Just take a very simple example. If you're a criminal defendant and you say, I want to represent myself, I don't want a lawyer. There is a colloquy that the judges are trained on. There's literally like, it's called the bench book. It's the book you keep on your bench. And you open it up to, page 55. And there's a colloquy where you as the judge say, I'm going to read you, the Fifth Amendment. It says you have a right to counsel. You know you're waiving that. Yes. Are you mentally competent to do this? Are you, aware? Have you had any mental health issues recently that would make you unable to do it? So the whole system that's necessary to establish that you're waiving your constitutional rights. And that's because waiving your constitutional rights is a big deal, right? Like it's not something we take lightly. And so when you talk to judges about it, I think they very much understand it. The other implicit right that you're waiving, that you don't even realize you're waiving, is separate from everything else that's part of this, is the First Amendment. Right? So the First Amendment says you have a right to free speech. The Supreme Court has always said one aspect of that is that you have a right not to speak. Another aspect of free speech is you have a right to associate with other people to talk about what you want to talk about. And one aspect of that is you have a right not to associate with people, right? Now, the government can make you associate with the government. The government can force you to pay taxes, and even if you're a pacifist, the government can still spend your money on aircraft carriers. But we, the government, can't make you associate with private organizations. And so there was an important case at the US Supreme Court a few years ago called Janus that my law partner was involved in. And the question was, can you make a public employee that doesn't want to join a labor union nevertheless pay money to that union? And the Supreme Court said, no, you can't make people join or pay money to a private organization that they don't want to. Does this look like it's to anybody? Right? So, I mean, it just points out the entire structural flaw with the fact that it's a private organization, that you are having the government, which can force people to associate with the government, instead trying to act through this private organization and then just say, well, you're going to waive your First Amendment rights, and you're going to waive your Fifth Amendment rights, and you're going to waive your Seventh Amendment rights, and if you don't, you're just going to have to go find a new job. Like, that's just not the way that the Constitution has ever worked. I think judges understand that, and I'm really hopeful for our case, but I'm very separately hopeful for Brent's case. We've got a great judge. There are different arguments than the arguments that I'm making. I think they're very good arguments. I think they're very easy to relate to arguments for judges. And ultimately, I think it's just going to create more chaos in the system. And, I don't usually think of myself as an agent of chaos. I usually am the agent of order, at least around my house. But here the goal is, I think, to have agents of chaos just throwing sand in the gears in order to force the kind of long-term resolution that Ed is talking about.
And one real quick question, I know we're out of time, but Daniel, to you, and we sort of talked about this before, Texas versus Bonner, which was in the Fifth Circuit, where the Fifth Circuit in January agreed to hear it en bloc, meaning all the members of the Fifth Circuit will hear the argument. And that argument is that the omnibus bill that was passed that started HISA is unconstitutional because there wasn't a physical quorum when that was passed. So 88 representatives that voted in favor of it and 100 that voted against it that were physically present, but it passed because of the proxy votes. And that's the thing that Judge Hendricks, who was the judge that started this whole issue with us in Texas, public Texas, wrote the opinion that said that this was an unconstitutional violation of the quorum. Do you think that has any legs?
Yeah, so we'll just very quickly go back to the world of 2020, where everybody was working remotely, and that included members of Congress. Members of Congress weren't physically showing up at the Capitol. There are rules in Congress about casting votes. And one of them is generally must be present to win, right? Must be present to cast vote. And so the particular 1,000-page COVID omnibus bill that this thing got originally snuck into was adopted in these sort of extraordinary set of rules. And there are a whole bunch of other things on the other 998 pages of that bill.
2,246 days.
2,246 pages of that bill, right? So it's like a really big problem, right? And if Congress has to re-adopt all of those things, some of it's moved, right? It was 4 years ago, 5, 6 years ago, like the world has moved on. Some of it is non-controversial. They all said HISA was non-controversial, and here we are. Right, so I do think it is a real problem for them. And it just goes back to this kind of, I think, fundamental goal that I have, that we have, like, we want as many avenues as possible to give as many arguments as possible, to have as many options as possible, all with the same goal of clearing the space, getting back to square one, having everybody have lived with this reality and recognized it was not a good reality, and then having actual consensus within the industry to create a new better reality. That's the goal, and this is one way to do it.
Thank you guys very much. We give them a hand, I really appreciate it. Most of them will be around for most of today, especially, so if you got any questions, let them know. And so again, we appreciate the opportunity to have their expertise in this topic.